the people have any additional motions, Mr. Bullock?
I asked the court to observe that we have a scheduling conflict. There are two jury trials currently scheduled for this division on July 21st. There's the Miss Martinez's matter as well as Ms. Troutman's. The speedy trial in this case does not run until August 18th. It would be my request that we schedule the matter, reschedule the trial to time within that speedy trial time.
What's your position with respect to that request, Ms. Troutman?
Well, the position with respect to that particular request
Yes.
of rescheduling the jury trial,
Yes.
I can, I don't have a problem with rescheduling it out, as long as it doesn't conflict with my schedule.
Okay.
But there's also some elements I think that are missing from the case. There was no affidavit from a known victim with injury in fact.
All right. So what I'm going to allow you to do, I'm dealing with the people's issues, and then I'll let you state your issues as well. Okay.
Sure.
So why don't we see if it is possible to reschedule? Are they both in Benton County? Is that correct?
Yes, both are in Benton County.
Why did you think that? As far as you know, is the Martinez case going, Mr. Bullock?
Judge, we were ready for jury selections last time. I've heard no communication from Mr. Gutierrez.
All right. Is this a 3-day trial? And let me look at the felony complaint. Four counts, all occurring on the same date. A number of witnesses, I imagine a number of those witnesses are Department of Corrections inmates who are not going to be called. Is that correct?
That's correct, Judge. I would anticipate that 5 witnesses. I think we could do it with the trial within 2 days.
We'll look for 2 days before August. What was the speedy, Mr. Bullock?
August 21st. No, I'm sorry, August 18th.
We have your case conflicting with another case. That case comes on at 1:30 today.
I traveled to be here today, so where to travel?
Your intentions are what?
Where to travel back. It already takes up a very large portion of my day.
Okay.
Wednesday through Friday is kind of
Busy.
business days.
Your busier days.
Okay, so that's why Monday, Tuesday, I could make a Wednesday work.
But a Thursday, Friday is particularly difficult for you. The other option we have, it would be up to you, but if with your consent and advisement, I would advise you regarding this matter, but we could continue the matter in order to try to find a Monday or a Tuesday past the speedy trial deadline.
And I would need to waive my speedy trial rights.
Correct.
I guess my hands are tied in the matter. I won't be waiving any of my rights voluntarily.
Okay. Do you have motions that you would like heard in this case?
Yes, I need to make the record. The record is that I previously submitted the tender of special deposit, but it also included all the oaths of offices. So I accept all your oaths of office and I bind you to them. The other matter I would like to bring attention to is the lack of improper service and the waiver of service that was sent to me by a Cheryl Martin in response to that. Oh, the other thing was that the victim in fact is not present with injury in fact. I don't know if there's a part in that discovery where it is. I didn't see it. And the other thing was with the jurisdictional elements, the constitutional requirements, knowing the nature and the cause of the action is my Sixth Amendment protected right. The court mentioned that they believe that they have jurisdiction, subject matter jurisdiction, but it wasn't actually proven for the record. So I asked for the delegation of authority as well, so that I may proceed knowingly.
I'm sorry, I don't understand what you're saying. And
Am-
you didn't file any written motion, so I can't even really look at those, but go ahead. Tell me,
So-
tell me what you mean.
Is your delegation of authority, Judge McDonough?
Like delegation of what authority?
Yes, what part of the Constitution are you operating out of? What is your delegation of authority?
I'm not going to answer questions for you on the record, obviously. But
Oh.
the court is operating pursuant to the laws, which means the statutes and the Constitution of the state of Colorado.
And the Supreme Constitution, which would be the national constitution as well, because that's the
Only
supremacy.
to the extent that the Constitution leaves matters up to the state to determine the manner in which they desire to exercise jurisdiction and run courts in each of the 50 states.
And it is solely judicially, correct?
No, it's legislatively and constitutionally.
Okay, then I think
I don't know what you mean by solely judicially. I'm sorry.
Article 3, Section 2 of the
Of
Constitution.
the United States Constitution.
Yes, which,
That defines federal courts.
sure. And state courts have to, if there's any conflict between that clause and state constitution, then the state constitution would have to give way to the federal.
Correct.
Well, thank you for saying it was legislative. I think there's a false presumption of law that I have not been able to rebut. Just to, my submitting to the court my notice and declaration of beneficial standing as one of the people, not to be confused with any Adamsonians or legal fictions.
Mr. Bullock, any response?
Yes, Judge. The statements and arguments made by Ms. Troutman aren't recognizable under the state law of Colorado or the United States. I understand that she may have questions, but the oath that we took is to follow the laws of the state of Colorado, and there's been no alleged violation of the statutory authority or the constitutional court's authority without any specificity alleging some kind of violation under the provisions of the law that provide adequate notice. We really aren't in a position to argue Ms. Troutman's claims. I can tell the court that I would address the two issues of the waiver of service. Ms. Troutman has waived the jurisdiction of this court by her appearance. The victim in the fact is the people of the state of Colorado. So I appreciate the issues she brings up, but I stand by my statement that they're not based under the applicable statutory or constitutional authority.
Thank you, Ms. Troutman.
There has been no known waiver of service because I have shown up here every single time out of honor and in good faith to settle and address the matter. There is no waiver of a rights or waiver to prove jurisdiction for the record. Also, as me being one of the people, I am afforded the right of judicial process. So I'm not sure what not understood about that. That's where the nature and the cause of the action is so important. And cause of action statutorily, but the nature is still has not been revealed. These crimes seem commercial in nature.
Bullock, was the summons served, or are you relying on the fact that Ms. Troutman has come to court and waived any prospective service? Does your file reflect that there was any service made?
Our basis on her voluntary appearance in court. Apparently it was sent to her, but it was not actually served.
All right, last chance, Ms. Troutman. It's your motion, so I'm giving you the chance to go last. Is there anything else you want to say?
That I object to them solely basing their service off of my appearance made out of good faith and in honor.
All right, thank you. The court is going to deem that Ms. Troutman has waived any jurisdictional defects to personal jurisdiction based on her voluntary appearance in court.
Voluntarily, but under duress and threat and coercion of bodily harm via the warrant that would be issued and resulting assault and battery and kidnapping that would ensue should I not appear.
The court notes that Ms. Troutman has appeared on October 25th, on December 1st, on January 5th, on January 21st, on February 2nd, on February 18th, and then on today's date, Troutman has submitted an application for a public defender in this case. Court deems that it has personal jurisdiction over Ms. Troutman sufficient for it to proceed on the matter.
And by what deem is that? Because
By what deem?
yeah, like what do you deem the court's personal jurisdiction on?
Your voluntary appearance in this court on numerous occasions.
My voluntary appearance that isn't voluntary? That it's under threat, duress, and coercion?
There was nothing compelling you to appear. You've appeared on numerous occasions. Really, the court established jurisdiction at your first appearance.
I have prima facie evidence from text messages received saying that should I not appear, it may result in a warrant, which false imprisonment is equivalent to assault and battery and kidnapping.
The court will allow you to file those and to make a record regarding that matter. The court deems it has jurisdiction. You have other motions that you have filed in this case.
The beneficial ownership is third-party intervener to the property in the case.
I don't know what that means. I know that the court had prepared an order related to the jury trial that's scheduled in this matter. That jury trial required you to file any written motions by a date certain. You were given until the close of April 1, 2026. You file motions in this matter. No motions have been filed. The court doesn't understand your oral motion, doesn't believe it's legally sufficient.
Then
Mr. Bullock, do you want to be heard on that matter?
Your Honor, again, I do not have sufficient notice in which to respond to any motions that Ms. Troutman's arguing. I can tell the court that her statements are not recognized as any particular defense recognized by Colorado law. Till I have legal analysis as to what her claim is, I'm really in no position to go forward.
Court is going to deny the oral motion on the record. I take it as a motion to dismiss, really based on subject matter jurisdiction, indicating that the matter is primarily commercial and not criminal in nature. However, the people have initiated this by the filing of a summons and complaint. That complaint does set forth several charges against Ms. Troutman under the criminal laws of the state of Colorado, and that's how the court will proceed in this matter. Are there additional matters that you want to bring before the court's attention?
For the record, I would like to give notice that there are rights, titles, and security interests that are obviously uncognizant to this court.
So the court will allow the record to stand in the terms of Ms. Troutman's position that there are right, titles, and other interests not subject to the cognition of this court. The court is going to include the motions hearing set for today. The matter was also set for pretrial readiness conference. Mr. Bullock, are the people prepared?
We are for both dates.
Have you had contact with any victims or witnesses in this case?
Your Honor, all of the witnesses are correctional officers or forensic scientists with the Colorado Bureau of Investigation. All of our witnesses for the trial are under subpoena. They're prepared to proceed.
Thank you. Ms. Troutman, are you prepared to proceed to trial on this matter? You have a copy of the court's order setting this matter for jury trial?
I do. I am getting the copy of the file from the clerk.
You're going to want to be aware of that particular order, as it will control the proceedings.
In the jury selection?
The jury selection as the matter goes to trial, okay?
Mm.
There's some matters of jury selection that you'll discuss with the trial judge on the morning of trial.
Who will be the trial judge?
The trial judge will be the judge who's sworn in to replace me.
Moving forward under threat, duress, coercion, and the extreme inequities of this case.
Right. The court has previously advised you extensively related to your right to have counsel. Do you recall that advisement?
I recall that it is my right to have counsel. It is also financially unattainable. So it's kind of like a rock and a hard place, inequitable.
I understand that you've made application for court-appointed counsel, and I appreciate that. The court determined based on your income that you were not eligible for counsel.
Mm.
That applies also to advisory counsel, which we discussed as well. So I understand your position, and
and I have a right to also represent myself, but if the court is not operating under the common law and it's purely legislative, then how is that constitutionally valid again?
I don't understand the question. I'm sorry, Ms. Trump.
Okay.
Yeah, jury selection. So what will happen is you'll come in, you'll have a conference with the judge at 8 o'clock.
Mm-hmm.
You'll be back in front, seated where you are now at 8:30. At 8:30, the court will start the process of, or about, depending on how long it takes to check in the jury, the court will begin the process of selecting a jury.
And where are the rules regarding this jury selection?
Colorado Rules of Criminal Procedure and the statutes of the state of Colorado. Both court rules and statutes govern jury selection process.
Okay. Tentatively, trial will happen on August, should it not be moved to federal court before then. this is my notice to seek redress and continue the matter for constitutional review.
Anything else from your standpoint today, Ms. Troutman?
All rights are observed, cognizable and unrecognizable to this court.
Thank you. Court will be in recess on this matter.
That wraps up Brenda Troutman's hearing. Much of today's proceeding focused on scheduling her upcoming jury trial, but the defendant also attempted to raise several procedural and jurisdictional issues. She questioned whether there was an identifiable injured victim, challenged the court's authority to hear the case, and requested proof of the court's delegation of authority before the proceedings could continue. The judge kept the hearing focused on the issues properly before the court, explaining that many of the defendant's concerns had not been presented through formal written motions and clarifying that the court operates under the Constitution, Colorado law, and the statutes enacted by the legislature. Rather than allowing the hearing to become sidetracked, the judge addressed the scheduling conflict, discussed the defendant's speedy trial rights, and moved the case forward within the legal framework governing the proceedings. Now it's your turn. Do you think the judge handled the defendant's arguments appropriately, or should the court have spent more time addressing her jurisdictional challenges? Share your opinion in the comments below. If you found this courtroom hearing interesting, be sure to leave a like, subscribe for more real courtroom breakdowns, and share this video with anyone who enjoys legal analysis and courtroom drama. Thanks for watching, and we'll see you in the next one.